Hi, everyone, and welcome to CCK Live. I'm Amy Odom. I'm an attorney here at CCK, and today I'm going to be talking about the recent Supreme Court decision in Arellano versus McDonough. Now, if you are a avid watcher of CCK Lives, you may remember this case. We talked about it a few months ago. Mr. Arellano is a veteran who served in the Navy in the 1970s. As a result of what he experienced during service, he developed severe PTSD, and he claims it was so severe that he was unable to appreciate that he could file a claim or help himself in filing a claim for VA disability benefits for nearly 30 years following his discharge. It wasn't until 30 years later that his brother helped him in putting together a claim to file at the VA for benefits for his totally disabling PTSD. That was in 2011. And the VA did grant the claim and assigned a 100% rating, but effective only 2011, which is the date that he filed his claim. This is consistent with the law, the statute 38 USC 5110A, which says that the effective date of benefits is generally the date of the claim. There is an exception to that rule, though, that's also found in the statute. That's in subsection B, which says that if you file your claim within a year of discharge, so Mr. Arellano was discharged in 81, so if he would have filed a claim by 1982, then he can get the effective date of the day after discharge. So his effective date could have gone back to 81 had he filed that claim within the first year of discharge. Well, Mr. Arellano argued that deadline should be extended, that 1-year deadline, because of his mental illness, which prevented him from being able to file a claim. And this extension is generally referred to as equitable tolling. And the general rule is that if there is a statutory deadline to do something, to file something, for example, to file an appeal at the Veterans Court or to file a notice of disagreement at the VA, then you can get that deadline extended by this mechanism called equitable tolling. But you need to show that there was an extraordinary circumstance, and the courts all agree that a mental illness that actually prevents a veteran from being able to handle his own affairs is an extraordinary circumstances that generally will warrant equitable tolling. But the Federal Circuit Court of Appeals, which is the superior court to the United States Court of Appeals for Veterans Claims, has long held that equitable tolling is not available for that 1-year deadline of filing a claim, that's not the kind of deadline that Congress envisioned equitable tolling would apply to. And they held that here in Mr. Arellano's case. A split en banc panel of the Federal Circuit, en banc meaning all the judges, so every judge on the Federal Circuit took a look at Mr. Arellano's case, and a split court issued a decision that basically upheld the previous law, which is that equitable tolling doesn't apply to this 1-year deadline. And Mr. Arellano appealed that decision to the Supreme Court. So now the Supreme Court of the United States, for the first time, had the opportunity to review this question, which is whether that deadline under 38 USC 5110B, that 1-year deadline for filing a claim to get that effective date of the day after discharge, can be extended or equitably tolled in where there's an extraordinary circumstance. Unfortunately, the Supreme Court held that it cannot. While there is a general presumption, so a general rule that Congress always intends for equitable tolling to apply to statutory deadlines, the Supreme Court here held that presumption was rebutted because 5110, the statute setting out the effective dates of benefits, has the general rule, as we just discussed, that the effective date is tied to the date that you filed the claim. And here for Mr. Arellano, that was 2011. And Congress then provided specific exceptions to that rule, 16 of them, in fact. And one of them, in fact, is subsection B, which is if you file the claim within a year, your effective date will go back to the day after discharge, even if you file the claim 300 days after discharge. And so the Supreme Court held that because Congress created all these specific exceptions to that general rule and put them in the statute, that clearly signaled that Congress did not intend that the courts, like the Veterans Court or the Federal Circuit or the Supreme Court, could create additional exceptions using the rule of equitable tolling. So what does this mean for veterans? Well, it means that equitable tolling that is not available when we're talking about deadlines to file claims with the VA for specific effective dates. Now, this does not mean that all veterans must file claims within a year of discharge. That's only to get that effective date of the day after the day of discharge. Veterans can file claims at any time, but this case is about when you must file a claim to get an effective date of benefits that's earlier than what the general rule provides, which is it's the date of the claim. It shouldn't really do much, this case, to alter VA's current practices. We had all been operating under the assumption, because of the previous Federal Circuit case law, that equitable tolling didn't apply anyway. So the Supreme Court has just confirmed that it does not. And this decision really emphasizes the importance of making sure you file your claim as early as possible. VA has a program now where you can file what's called an intent to file form, even if you don't know exactly what you're going to claim or what disabilities you have. You can file this form, and that will be a placeholder, and your effective date will go back to the date that you've submitted the form, as long as you file an actual application within a year. Also, the Department of Defense and VA are a little bit better at making sure that service members are informed about how, where, and when to file a claim than they were probably in Mr. Arellano's time. Both agencies should be assisting service members in preparing claims as they exit from the military. And also, the Supreme Court did leave open the possibility that there are some situations where those deadlines could be excused, just not for equitable tolling. For example, in a footnote, they identified estoppel and waiver as potential ways you can get around those deadlines. Now, those are going to be pretty difficult cases. Generally, estoppel and waiver doesn't apply unless VA does something really bad that prevents you from being able to file a claim. And we have a particular case right now sitting at an en banc panel of the Federal Circuit called Taylor versus McDonough. This case involved a veteran who was a human test subject at Aberdeen Proving Grounds and was made to take a vow of secrecy about what had happened to him, and told that he would be criminally prosecuted if he did divulge what had happened to him during service as a human test subject. And then many years later, when the program was declassified, he filed his claims for VA benefits. And one of the questions before the Federal Circuit panel now is whether the government can be stopped or legally prohibited from raising 5110 in the general rule that it's the date of the claim is the date of the effective date of the benefits, when the government itself prevented him from being able to file any earlier. So all eyes on that case now, that we have the answer as to whether equitable tolling is available. It's not, but perhaps estoppel will be available in situations like Mr. Taylor's, where the government prevented him from being able to file a claim. Be sure to keep in touch with us. We'll be giving progress updates on Taylor, and we really appreciate you joining us. Please be sure to follow us on social and subscribe to our channel to stay in the know about veteran-related news and VA benefits updates.